Today, Daniel Medwed is University Distinguished Professor of Law and Criminal Justice at Northeastern University and the legal analyst for GBH. His work focuses on issues related to wrongful convictions and prosecutorial accountability. Before entering the academy, he served as a public defender with the Legal Aid Society in New York City and ran the day-to-day operations of the Second Look program, a clinic at Brooklyn Law School that investigated and litigated innocence claims by New York State prisoners. His recently published book, Barred, Why the Innocent Can't Get Out of Prison, was included in Bloomberg's top 10 list of best books in the fall of 2022. Most notably is a Cambridgian, or a Cambridge kid, who grew up on Avon Hill and occasionally still dreams about the ice cream sodas at Bailey's in Harvard Square. In the silver.
Oh, yes, yes.
The magazine rack at Reading International, that's a long time ago, and the shish kebab at the Acropolis. Welcome, Daniel.
Thank you. Thank you. Thank you, Myra. It is such a delight to be here. Can everyone hear me? Fantastic. So first of all, gosh, there are so many familiar faces, many of whom I owe an apology, because years ago, I undoubtedly trespassed through your backyard at some point with a bunch of other Cambridge ruffians. So I suspect the statute of limitations has passed on those crimes, but it's never too late to apologize. It really is delightful to be here. So I will speak for a few moments about this book and then open things up for questions, okay? So there are legitimate and illegitimate reasons for writing a book. A legitimate reason is you have a great idea that you really think is worth saying something about. The other reason is the reason I wrote this book, which is that my dean asked me to take on an administrative task. And as an excuse, I had to come up with something on the spot. And I said, I'm writing a book. And fortunately, he didn't ask the inevitable follow-up question, which is, what's the topic? But I thought he might, so I began to really think, what issue is nagging at me? What issue is really pressing in terms of my research? And this is what I came up with. So at this point, there have been more than 375 documented DNA exonerations in the United States since 1989. Cases where somebody was wrongfully convicted, a factually innocent person, and then later, because there was biological evidence retained at the crime scene, it was tested through DNA, and voila, the person was determined to be actually innocent. Great. But DNA is just the tip of the iceberg, and there are many, many, many other non-DNA cases that are much harder to prove that we have struggled to prove over the last 34 years. But we know now why these cases go wrong at the front end. We have this data set of cases for 34 years, and we can study why an innocent person might be convicted. And some of them are pretty obvious. People make mistakes in identifying other people. Eyewitness misidentification. Prosecutors and police occasionally commit misconduct. Junk science, flawed forensic evidence is often used in courtrooms. Poor defense lawyering can be a major contributing factor. So I couldn't really write a book about that because other people have done that, and it's not especially interesting. But something that's always intrigued me, at least since I started doing this work nearly 25 years ago, is how it's so easy to convict people on the front end. Really relatively easy to convict them on the front end, but so hard on the back end to get them out, even when you've accumulated substantial, compelling new evidence of innocence, okay? So I'll do two things during my talk before we open things up for questions. The first is I'll just set the table. There may be some non-lawyers here. Just describe the panoply, the range of potential remedies that are out there when you've been convicted. And then I'll tell you a war story that I hope will illustrate how this works or doesn't work in practice, okay? So as you all know, we have a constitutional right to a jury trial for criminal cases. And it's mentioned twice in our US Constitution. And all of our due process protections, virtually all of those protections, are afforded at the trial stage. Believe it or not, and I was surprised about this when I was in law school, there is no reference to a right to appeal in the US Constitution. There's no right, no constitutional right to appeal your conviction under the US Constitution. Now, every state affords you that right by a statute, by law. And if a state didn't provide it, it would probably be a constitutional violation in and of itself. But the US Supreme Court has said this. The trial is the main event in our criminal justice system. The appeal is the undercard. It is less important, okay? So the first remedy, often when you're convicted, is to directly appeal your conviction. It's called the direct appeal, and you're constrained to the issues that were raised at trial. I like to call it a vertical remedy. You can only attack directly what happened at trial. You can't bring in new evidence. You can't even typically bring in new arguments. You are limited to the things that were raised and discussed at trial. So it's a really ineffective mechanism for reversing a factual injustice. How can you prove that someone is factually innocent when you can't introduce new evidence? And the whole system of the direct appeal is predicated on deference to what happened at trial. So then there are other remedies that are out there. They're called collateral remedies or post-conviction remedies. Unlike the direct appeal, which is a vertical remedy, you can use these remedies to attack the conviction from the side. One of them is the famous writ of habeas corpus, which some of you have probably heard about. It is referenced in our Constitution, and originally it dates back to ye olde England. Habeas corpus means show me the body, you have the body. And it's a way of forcing the government, originally the crown, now our president or our governor, why they have someone in detention. Government, tell us why somebody is being detained. It's a vehicle, this writ of habeas corpus, that you can use prior to trial, notoriously with the Guantanamo Bay cases, where people, and still, are detained at a base off Cuba without being charged with a crime, but they are being suspected of terrorist activities. And some people, detainees, have been able to successfully argue that it violates their rights. Show me, government, why you are detaining me. But for my purposes, it's also used post-conviction. You can use habeas corpus as a way to attack a conviction. And not just in state court, you can even go into federal court, and you can have a federal judge take a look at a state conviction. But here's the problem. It has never been a vehicle either for addressing actual innocence. Typically, habeas corpus only will recognize constitutional claims or jurisdictional claims. And famously, or rather infamously, in a 1993 US Supreme Court case, the court said, innocence alone is not recognizable in habeas corpus. It involved a man on death row in Texas. He was about to be executed, Lionel Herrera. And he had an affidavit from his brother, who had since died, but it was an affidavit from the brother saying that he had committed this crime. And there were other affidavits from people who said the brother had confessed to this crime. But the US Supreme Court said, no, this is not the appropriate place, the appropriate forum. And he was executed without a court ever fully vetting the newly discovered evidence back in 1993. Another post-conviction remedy, which is less well-known, but something I'd like to talk about because in theory it's just this wonderful avenue for justice, is something called the writ of error coram nobis, which I bet many of you, except for Justice Stuffley, have heard about, right? The writ of error coram nobis means before us, and it's a 16th century post-conviction remedy from England that allows you to go back to the original trial judge after a conviction, present that judge with newly discovered evidence that casts doubt on the integrity of the case, and you get a new trial. So that sounds great for people like me who are investigating claims of innocence and coming up with new evidence. Couple problems, though. You're going back to the original trial judge, who may already be vested in the outcome of the case if he or she even remembers the case. Second, the courts have interpreted the phrase newly discovered in a very parsimonious, stingy way. It not only has to be new evidence, but it has to have been evidence that couldn't have been discovered before trial. So oftentimes you'll find newly available evidence, but you can't prove that it was not discoverable then. And the court will say, well, you could have raised it then, you snooze, you lose, you're out of luck. So then the last remedy is clemency. The power of the king originally in England, now here in Massachusetts, the governor, at the federal level, the president, to issue a pardon or a commutation to somebody behind bars. And in fact, in that 1993 Supreme Court case that I talked about, Chief Justice Rehnquist said, it's okay that we don't have innocence in habeas corpus because there is clemency out there. Clemency is, quote, a fail-safe to protect the innocent. Guess what? It's not. Clemency is not a fail-safe. Chief Justice Rehnquist vastly overstated the extent to which clemency is a guardrail, for really two reasons. The first is the historical purpose of clemency is all about forgiveness. My youngest daughter, Clementine, based on the goddess Clementia. Julius Caesar would cite the goddess Clementia to extend mercy to his enemies on the battlefield. That's the origin of this idea of forgiving your enemies, forgiving people who've sinned. If you're innocent and you have not transgressed against societal norms, how can you seek forgiveness? You can't be forgiven for something you didn't do. So the pardon power is just an ill-fitting suit for these innocence cases. The people who get pardoned are people who commit crimes, maybe when they were young, or maybe they're survivors of domestic violence and they've acted out against their abuser, and they've reformed themselves, rehabilitated themselves in prison, but they're factually guilty. Those are people who deserve mercy. But why not the factually innocent too? They should deserve mercy of a different sort, mercy writ large, okay? So these vehicles that are out there that a lot of people talk about as a way to course correct, to correct for injustices, actually don't work. And we've all heard the phrase, the American criminal justice system isn't perfect, but it's the best we have. I will claim for you that is wrong. That is just wrong. That is not grounded in data. That's grounded in self-satisfaction, okay? Here's a story that I think will illustrate how these different remedies converge to potentially prolong an injustice, okay? So how many of you have been to Suffolk County? It's a trick question. Suffolk County, New York. Suffolk County, New York. Suffolk County, New York. Okay. For those of you who've been to Suffolk County, New York, how many of you have been to the county seat, Riverhead? Oh, two people. For the two people in the room who've been to Riverhead, have either of you been to the town of Brentwood? Brentwood, New York.
Somebody.
Brentwood, New York? I can't say bad things about Brentwood, or may I?
I'm sorry?
May I say bad things about Brentwood?
You may.
Okay.
I was there many years ago.
And it got much worse after you left?
Yes.
Okay. So on February 3rd, 1999, at 8:20 p.m., a large white man went into a restaurant at a strip mall in Long Island. Strip malls in Long Island, do they exist? It wasn't a popular restaurant because the only people inside were the cook and the waitress. There were no patrons at all. The man ordered a shrimp dinner, and while the cook was preparing it in the back, the man took out a knife, put it to the throat of the waitress, and said, "Open up the cash register." She complied, gave him $32. Again, it was not a successful restaurant. She screamed, the man fled, and the cook came out of the kitchen. They both caught a fleeting glimpse of this man, tall, heavyset white man, mid-30s, who fled in a late model white car with New York plates, a T and a 1 in the license plate. That's all. Large, heavyset white man, mid-30s, T and a 1 in a New York plate, white car. Okay? They call the police, and the police come down to the restaurant with what's called a six-pack. 6 photos of people who loosely resemble this description. Tall, heavyset white men in Suffolk County, coincidentally, all of whom have criminal records, because that's how you get your picture into a six-pack. You've been arrested or you've been convicted of a crime. Independently, both the cook and the waitress identify a local man named Stephen Schultz as the perpetrator. Now, Stephen fit the bill in 2 key respects. He was 6'2", 250 pounds, and about, if I recall, 36 years old, okay? He also had a lengthy criminal record, but he didn't fit the bill in perhaps the most critical sense. None of his crimes indicated a proclivity for violence. They were crimes related to his addictions, typically theft and drug-related crimes. Nothing whatsoever to do with violence, okay? They arrest Stephen. He claims to be innocent. He says that he was home with his roommate in a neighboring town watching an episode of Dharma and Greg. Do any of you recall that sitcom from the late 90s? Now, for those of you who recall that sitcom, would any of you willingly admit to watching the show if it were not true? It was not a very good show. It's a pretty peculiar alibi to concoct, right? This 30-year-old guy with his tough roommate watching Dharma and Greg? Come on. But it's not a great alibi. You're with your roommate at home watching Dharma and Greg. If I were to ask any of you where you were on February 3rd, 1999, your alibi might not be great, even if you could recall it, right? You're maybe with a loved one, a family member, something of that nature. He doesn't have money to pay for an attorney. So he's assigned a lawyer who picks up indigent defense cases. He's not with an institutional public defender office, but he's a solo practitioner who handles individual cases for money from the state. He shall go nameless, Barry. So Barry gets this case. And he does nothing. At that time, public defenders in Barry's shoes, they got $40 an hour for in-court work and $25 an hour for out-of-court work. The way he made a living as a lawyer and to actually pay his rent was simply by volume business. He would just pick up as many cases as possible. He'd get as many criminal cases as possible. He'd get family law cases. He'd do real estate transactions. And he'd basically triage based on who could pay. And at the bottom, of course, was the indigent defense case that didn't pay all that much. So he's not doing anything. Stephen has no money, so he can't get out on bail. And he's sitting in the Suffolk County lockup in Riverhead, right? In Riverhead, and he's reading the local newspaper. Now, for those of you, because a lot of you at the beginning indicated that you'd been to Suffolk County, Long Island, what would be the local newspaper for someone in Suffolk County, Long Island? Newsday, our friend from Brentwood, Newsday. He's reading Newsday. Okay, think the Boston Herald with a New York twist, okay? He's reading Newsday, and he comes across the following article, and I'm paraphrasing. Large white man pleads guilty to 6 robberies. Another man named Anthony Guilfoyle had just pled guilty to 6 storefront robberies in the Brentwood vicinity from January to March 1999, effectively bookending this particular crime in February 1999. His modus operandi, his MO, was to go into a business and to intimidate employees into turning over money from their cash registers. And there was a photo of this man next to the picture. He looked like he could be Stephen Schultz's brother. Stephen looks at this. He calls his sister, because his lawyer won't pick up the collect calls from the jail. He calls up his sister, Linda, call Barry, have Barry investigate this other guy, Anthony Guilfoyle. I was watching Dharma and Greg. Here's a guy who looks like me, who's pled guilty to 6 factually analogous crimes during this period in the vicinity. Call the lawyer. She calls Barry. Barry says, oh, that's interesting. We'll see how it plays out. He never investigated it. He never went to talk to the waitress or the cook or show them a picture of this other man. He just went to trial. In the meantime, Stephen was offered a guilty plea. If you plead guilty to this robbery, Mr. Schultz, you will get 3 years in prison. A pretty good deal for someone with a hefty criminal record like Stephen Schultz. He said, no, I'm innocent. I'm not going to cop out to something I didn't do. I know I'm facing north of 10 years in prison if I lose at trial, but I'm innocent. The truth will prevail. Here's what happened at trial. The cook gets up on the stand first, and he looks at Stephen Schultz and he says, that's the guy. That's the guy who came into my restaurant, ordered a shrimp dinner, then did something to the waitress. I was back in the kitchen at the time, and I saw him run into a late model white car with a T and a 1 registered in the state of New York. It later turned out that this man had his own pending gun possession charge that disappeared shortly after his testimony against Stephen Schultz. Then the waitress took the stand. This is the pièce de résistance in every case, right? The actual crime victim. And for those of you who watch police procedurals, what happens on TV? You got the crime victim. It's usually, in my experience, and I watch these shows all the time, ostensibly for research. That's what I tell my wife. I got to watch Law and Order Orlando just for research purposes. Either the crime victim points sort of a wavering finger at the man and says, "That's the man," right? Kind of empowered victim moment. Or it's the bold victim moment. "That's the guy. I will never forget his face." Usually, right? It's one of those two tropes. But in this case, something happened that I had never seen, and I have still never seen. She looks at him and she says, "Now that I see him in the flesh as opposed to a picture, I realize he's not the guy. The guy who committed the crime was taller and heavier. This other man, Anthony Guilfoyle, whose photo was in Newsday, who had pled guilty to 6 factually identical crimes during this time frame and looked exactly like Stephen Schultz, was 6'4", 350 pounds, 2 inches taller and 100 pounds heavier than Stephen Schultz." Now, the defense lawyer, Barry, at this point, had a really interesting strategic choice. He had not done his investigation. He had not shown this picture to the waitress. And an axiom of cross-examination is you should never ask a question you don't know an answer to. So what if he went up to her and showed her the picture and she said, "Nah, not the guy either"? What are the chances that there is a third, tall, heavy-set white guy in his mid-30s running amok in this really crappy, can I say that, town in Long Island? So they're just going to think that she was scared or she's lying. So it's too risky to ask her that question. So instead, what he tried to do was a compromise. He tried to introduce the photograph from the newspaper into evidence so the jury could look for itself and see whether or not there might be reasonable doubt about whether this man, Stephen Schultz, committed the crime. Look, here's a guy who pled guilty to other crimes that are similar. He looks a lot like my client. Take a look. Could there be a mistake here? Seems like a reasonable thing to do. But under the rules of evidence in New York State at the time, in order to introduce evidence of what's called third-party guilt, that someone else committed a crime, you had to show a clear link between that person and this incident. Circumstantial evidence wasn't enough. It wasn't enough that he pled guilty to all these other crimes. There was no evidence placing him at this restaurant in Brentwood on February 3rd, 1999. So the judge, interpreting the law as a matter of discretion, said no, you can't show the jury the photograph. Jury then returns a guilty verdict. They believed the cook over the waitress. Stephen was convicted of first-degree robbery and sentenced to 11 years upstate in New York State prison. He writes to me at Brooklyn Law School. We had just started our clinic at Brooklyn Law School where we were investigating and litigating innocence cases. And the timing was great because we were just starting out and we needed cases. If he had written me 3 months later, I wouldn't have been able to read the letter. It was just perfect timing. So I got this, I'm like, oh, we have to take this case. This is a really good case. And so we took the case. And here's what we did. We first did the direct appeal that I mentioned, that vertical remedy that challenged what happened at trial. But as I indicated at the outset, it's an ill-fitting suit for an innocence claim because you can't introduce newly discovered evidence. You can't. So we challenged the judge's decision to exclude that photo from evidence. We said it was an abuse of discretion. In a case like this with such compelling evidence of innocence, why not let the jury decide for itself? We lost. We lost. because the appellate court, to some extent, was constrained by the rules of evidence and had to apply a very deferential standard of review. The judge didn't abuse his discretion. Maybe it wasn't a great decision, but it wasn't an abuse of power by the judge to do it. So we lost unanimously on that. Then we began to investigate the case, because New York has this coram nobis remedy that I mentioned that allows you to bring newly discovered evidence back to the trial judge and seek a new trial if you can convince the judge that justice may not have been done. So here's what we found, right? My intrepid students found TV Guide. Remember TV Guide? And from 8 o'clock to 8:30 p.m. on February 3rd, 1999 on ABC, a particular episode of Dharma and Greg was airing. We then found the roommate who the defense lawyer had failed to consult, and the roommate struck us as extremely credible. He had no criminal record. He was a disabled mechanic, a straight shooter, straight talking guy. And he said, yeah, we were watching the show. Want me to sign something? Then we found the waitress, who was hard to locate because she was in this country without proper documentation and didn't want to be found. But we found her, and we showed her our own six-pack. Unlike the police, however, I don't have the benefit of arrest photos as a law professor, let alone tons of photos of large, heavyset men in their mid-30s. So initially I thought about going around Brooklyn Law School and taking pictures of my students who happened to be large, heavyset men in their 30s. But I didn't have tenure, and I thought I could get in trouble for that. So instead, I just got two photos. One of my client, Stephen Schultz, and the other of this guy, Anthony Guilfoyle. Put them next to each other and showed them to this waitress. She said, oh yeah, that other guy is the one who did it. I'm 90% sure that that guy, Anthony Guilfoyle was the picture she was pointing to, is the man who did it. And then she signed an affidavit under penalties of perjury that that was her recollection. And then in the final piece of the puzzle, my students somehow, and I never asked them how they did it because you don't want to ask a question that has a bad answer sometimes, they somehow got access to state motor vehicle records in New York, and they determined that a car registered to the wife of Anthony Guilfoyle, Kim Guilfoyle, was a 1997 white Oldsmobile, registered in New York with a T and a 1 in the license plate. We got all of this together and we drove to Riverhead, because the first step was to convince the judge, the original judge, John Coppertino, that we should just have a hearing on this evidence. Let me examine the waitress. Let me examine the alibi witness. And then if you think maybe something went wrong in this case, then you could just grant a new trial. And if the prosecutors want to retry Stephen Schultz, that's their prerogative. I wasn't asking for a moon. I wasn't asking for the star. I was asking for a Bailey's ice cream soda. And I drove out to Riverhead with one of my favorite students. We do have favorite students, even though we don't tell them that, Roger. And I made an argument, because I wouldn't let him do it. I made the argument as to why we should get a hearing. And the judge looked at me and said, no. I recall that case. I didn't believe the waitress. I think she was just scared of your client. She shouldn't necessarily have to testify again. Denied. We never even had an evidentiary hearing. We were not allowed to subject these witnesses to examination in open court. We appealed that decision and we lost. We appealed that decision to the highest court in New York and we lost, with only a single dissent from one of the judges there at the highest court in New York, who said, there's something wrong with our appellate and post-conviction procedure if a case like this can't get a hearing. I don't know exactly what's wrong, but something is wrong. At that point, I had moved to Utah, the vagaries of the academic market. I was teaching, and I was sort of in touch with Stephen, but we felt like we couldn't do anything in his case. He then, on his own, filed a pro se habeas corpus petition in federal court. He went back to federal court, and he said, I should be released because my trial lawyer did not provide me with effective assistance of counsel. The federal judge gave him a hearing, and he called me, and like all good lawyers, once things looked like they were good, we swooped in. Sorry we abandoned you before, but now that it looks like we can get a win, let's take over, okay? Well, we were just shocked. We never thought we could get this. So 8 years after his conviction, a few months before he would have been released anyway for good time served, Stephen Schultz had this hearing, and a judge ruled in his favor. But not on the grounds of innocence, because innocence is not cognizable on its own in a federal habeas corpus petition, but on the grounds of ineffective assistance of defense counsel, a constitutional violation. And the judge explicitly said it was because that lawyer, Barry, did not investigate the third-party suspect, Anthony Guilfoyle, before trial, and he did not properly investigate the alibi defense. So Stephen was free. Stephen was free. And here's what's happened to him over the last 15 years. Because he was never declared innocent, he's ineligible for what's called wrongful conviction compensation money in the state of New York. So he never received any compensation, no civil remedy for what happened to him. He got a job as a long-haul truck driver, and he would call me from various points. They're like the highlight of my day. Daniel, I'm in Maine. I just tried lobster for the first time, which is great. He ended up connecting with a woman named Lisa, and they moved to New Jersey, which in and of itself is a sign that things are not going very well. He now lives in New Jersey with Lisa and their dog, Christmas, a stray they found on the 25th of December a few years ago. I'm in touch with him pretty regularly, and I talked to him recently, right before this book came out, because I wanted to verify some details. He'd given me permission to tell his story. And I asked him this question because I'd been curious about it. A question I ask a lot of people, formerly incarcerated people. What do you appreciate most about your freedom? And I was like, oh, this is going to be in my conclusion, like walking on the beaches of New Jersey with Lisa, or like playing fetch with Christmas. I was hoping for that one, because that would get tears, and sales. Right? And he said something very peculiar and curious. He said, my debit card. My debit card. I'm like, debit cards existed in 1999? Why is that the thing he appreciates most about his freedom? And he said, well, because on my route as a long-haul truck driver, I stop every 20 miles to buy a pack of gum or a pack of cigarettes or a drink, because it gives me an alibi in case the police come around to tag me for a crime I didn't commit. I'm sitting at my dining room table with my youngest daughter over Veterans Day, just a few months ago, and I get a text from Stephen. We need to talk. This is not a good thing from a former client. You want a little GIF or something funny or like a picture of Christmas. That makes me happy, not a we need to talk. Dan, do you know any housing lawyers in New Jersey? My landlord is evicting us. When you think about what Stephen Schultz has experienced, he had a criminal record, yes. A criminal record for theft crimes, a criminal record for drug crimes, not a criminal record for violence. He then spent 8 years in prison for a crime he didn't commit. He was ultimately freed, not on the grounds of innocence, but for some would say technical reason, a constitutional violation. He's received no compensation for that injury. He is not considered innocent in the eyes of the law. He carries that decision, releasing him, around with him in case somebody asks him about his prison record, which they may do, because his record has not been expunged. His case is visible to all if you go Google it online. And now he's in the process of being evicted. You can think about whether the American criminal justice system, our exalted, best in the world system, is in fact so great when this could happen to just this guy, Stephen, in Brentwood. Just the guy with problems trying to make it through this thing we call life. There is something wrong with our system, not just that we allow this to happen on the front end, but that we don't allow justice to be served on the back end, okay? And finally, before I open things up for questions, my one and only slide. There's Stephen with Christmas. Now, I'm a cat guy, I'm not a dog guy, but I'm a dog guy, like, you know. So thank you. I will field questions if there are any. Please don't be shy. Yes.
I just want to say how wonderful that was.
Thank you, Nan.
We were formerly colleagues at Northeastern. I also am retired from the SJC, and I was pretty proud, I was going to talk about that, with the fact that in Massachusetts we have plenary review of major cases.
Mm-hmm.
Yes. And I have a lot to say about that, make a contribution. But what I realized in listening to you, that's just the tip of the iceberg, right?
Yes,
Tip
it's
of
the
the iceberg. It's all these other people who don't commit those crimes that will not have the benefit of plenary review from the likes of me and get to live their lives out the way they do, sometimes with great difficulty, even though they have wonderful people like you to represent them. So thank you for what you do, and thank you for this wonderful work.
Thank you, Justice Duffley. One of the greatest jurists in the Commonwealth, Justice Duffley, was on our SJC, and then was kind enough to teach at Northeastern after she retired. So thank you for that comment. And things are better in Massachusetts, though I should note that I do talk about 2 Massachusetts cases in my book, so they're not perfect. They are, as Justice Duffley pointed out, though, cases that did not reach the SJC originally for a variety of reasons. And ultimately, when one of them did reach the SJC did reverse, right? So there are questions, even here, though we are better than most, in no small part because of great justices like Dan Duffley. Great. Oh, Beth.
Making this compelling case that there's something wrong
Mm.
with the justice system, which I believe.
Yeah.
Do you have any thoughts? I've thought about this a lot, about how the law could be changed to make it better?
Yeah, I have. And I spend some time in this book doing it. So here are some thoughts, and I'm curious what people think. I advance a bunch of what I call micro-level reforms. You know, you can tinker with the machine a little bit, and then several macro-level ones. So here are some micro-level ones. Why give so much deference to what happens at trial? Why let the judge get off for all of these decisions? Why shouldn't a judge on appeal be able to look at that decision about excluding the photograph of Anthony Guilfoyle and say, well, it wasn't the right decision. This person should get a new trial. Why do we afford so much deference to that first level actor? Part of it is the way that the trial is the main event and everything else is the undercard, but part of it, frankly, is collegiality. Judges belong to the same club. You get trained at the same schools. It's really hard to reverse a friend. Think how hard it is to tell your friend, you know what, that outfit does not look good on you. Like, let alone take the outfit off their back and return it, you know? Okay? I think it's a very difficult thing. So we could change the rules. You could make newly discovered evidence recognizable in habeas corpus. You could say that federal habeas corpus judges may consider actual innocence. Lots of little micro-level changes, premised on the idea that our system is pretty good, but we need to tinker around the edges. But then, I don't think that'll work, so I do recommend a couple of macro-level reforms. And here are a few of them. So one of them relates to the role of our prosecutor. You look at this case and you think, a lot of things went wrong. Stephen Schultz was misidentified by 2 victims. But this other suspect emerged before he even went to trial. Should the burden be solely placed on his defense lawyer to investigate it and figure it out? What about the government? What is the district attorney's office doing in Suffolk County? Our American prosecutors, they're often called district attorneys. Here in the Middlesex County, Marion Ryan is our district attorney. They are not just advocates for convictions. Since the 19th century, they've been called ministers of justice. It's often said that prosecutors never lose a case as long as the outcome is fair. If you have enough evidence to go to trial and you can't prove guilt beyond a reasonable doubt, that's a win for the government, because the government wins when justice is served. But that's not how it works. Prosecutors often view convictions and their conviction rate as the coin of the realm. It's the way to advance. The public doesn't pay much attention to these offices. DAs are elected in 45 of the 50 states. And wherever I've taught, and often when I give lectures like this, I'll ask people, do you know the name of your DA? And a shocking number of people don't. It's just, we might know our representative, we might know our state senator, we might know a lot of people. We may not know our district attorney, the people who control the liberty of folks in our jurisdiction. So one major reform I have is, let's make prosecutors ministers of justice. Let's realize this ideal by having them create their own internal innocence units where they are obligated and authorized to reinvestigate specious cases. Several offices have these units. They're called conviction integrity units or conviction review units. One of them in Brooklyn, New York, Kings County, my old stomping grounds, where I could never even get a meeting with the DA. That unit has now reversed 30 cases, played a role in reversing 30 really, really shaky cases, including one that involved a black man convicted of firing a gun at a police officer. And the Brooklyn DA's office reinvestigated this and said, we think this guy is innocent. It takes a lot for the DA's office to go against the police, and they did it, right? So that's one suggestion. Let's change this. Let's actually make prosecutors ministers of justice, not in theory, but in practice. The other thing I recommend is creating freestanding innocence commissions that are created by the legislature and are funded to investigate these cases. So one of the big problems, of course, is our adversary system, right? Prosecutors may want to look at cases that were problematic in their jurisdiction, but it also takes a lot for them to admit a mistake or to admit that one of their colleagues committed a mistake. Judges, because of collegiality and what scholars often call conformity effects, might not reverse their peers. So why not have an independent commission with independent investigative power, subpoena power, not unlike a congressional committee, that investigates and looks into these cases, and if the case turns out to be dubious, they refer the case to the courts with sort of a stamp. Take a close look at this one. We think that this is a good one. The United Kingdom has this in place. It's called the Criminal Cases Review Commission. It was created in 1995 after two notorious wrongful convictions, one of which was chronicled in a Daniel Day-Lewis movie, the Guildford Four and the Birmingham Six, where members of the IRA were wrongfully convicted of two pub bombings in England. And they were convicted in part because the UK said that nitroglycerine was found on their hands when they were trying to leave the UK on a ferry. Well, it turned out it wasn't nitroglycerine. It was a chemical substance found on playing cards. Very common. They were just playing cards on a boat. A bunch of Irish guys playing cards on a boat were arrested for bombing and killing people in Guildford and Birmingham, okay? So the UK responded to this, recognizing prosecutors aren't the ones who should be entrusted with looking at this. Let's create our own commission. It's been pretty darn successful in reversing hundreds of cases in the last 27, 28 years. Only one American jurisdiction has followed suit, North Carolina. North Carolina created this commission in 2006, and so far has played a role in releasing 15 people. It's not a panacea. It's not a perfect thing. People are concerned about whether this is a solution or not, because what if the commission misses a good case? What if the commission says, oh, Stephen Schultz, that's not a good case? How then are people like me supposed to convince a court that our guy's innocent if the commission has already said, we don't think there's anything here? So the commission, in a sense, could become judge and jury, and that's always a danger. But I think we need to explore these options. And the third macro-level solution is probably somewhat obvious based on the tenor of my conversation here, which is just creating a sense of empathy and inclusivity when we talk and think about criminal justice. There is so much of what I often call othering when people talk about folks behind bars, that they are somehow different. They are somehow different from you and me. Whether it's based on race or class or criminal record, they are different. Well, they aren't. They are Stephen. They are Stephen Schultz. They are people with lovers and dogs and trouble making rent and trying to make a go of it and to get a job. They are having, former clients of mine had Zoom birthday parties, right? Stephen has all of these stories about his time in prison, some of which are about the horrors of prison, but some of which are about sort of the moments of levity and beauty, even behind bars. One day I called him on his birthday. He was in a prison in Napanoch, New York, out in the Catskills. And it's actually a kind of a well-known prison for being a nice place, because they had a great warden at the time, to the point where inmates would call it Happy Nappy, Napanoch. So he was at Happy Nappy, and he was really, it's Eastern Correctional Facility. And I called him up. I was like, oh gosh, poor guy. You know, it's his birthday. He's behind bars. And he was in the best mood. When his counselor, you have to call the counselor to find him, and you have to arrange for it. And he's like, Dan, I'm in the best mood. I've had a great day. Guess what the guards did? Usually when your client says, guess what the guards did, it's not good, right? He said, yeah, they festooned my cell with crepe paper. I'm like, don't tell me that. Like, this undercuts my whole, like, take on the world, take down the prison industrial complex thing if they're festooning your cell with crepe paper. But then part of me is like, you know, they're humans. They're humans in cages, right? So ultimately, it's just empathy. You can change the system on a micro level and a macro level, but we can also change our hearts and appreciate the shared humanity that all of us have, and that we aren't just to be reduced to our worst moments that maybe we didn't even do, but other people think we have done. Yes?
You're such a good narrator.
Oh, thank you.
Reading your book will be a pleasure. I'm wondering if there was anything in the system that supported Stephen in going back to the courts and saying I was misrepresented. How did that happen?
Gosh, that's a great question. So there are a couple aspects in the system that could be used to deal with that particular issue. So that lawyer, Barry Levine, is registered under a panel in New York. It's called the 18B panel that says that you have to meet minimum qualifications of performance to get money from the state to handle these cases. So in theory, you could file a complaint with that board, the 18B panel, to say, you know, Barry Levine did not provide good service here, do not assign him other cases. So that's one sort of institutional fix that's in theory available. Another is to file a disciplinary complaint against him with the bar and ask for the bar to either disbar him or sanction him or suspend his license. So there are some other remedies that are out there that could be used to deal with this problem. The issue, however, and this is a really serious issue, is that the bar associations, the disciplinary committees, and these 18B panels do not take these claims seriously, because most of the complainants are aggrieved former clients who are immediately dismissed as having an axe to grind. Well, sure, you think your lawyer did a bad job because you're in prison. So immediately the perspective is to support the lawyer and to minimize the claim of the complainant, which is a real tragedy. But having experienced this and been a criminal defense lawyer, there's some wisdom to it. When I was a public defender, I handled appeals, and I had one case, I had one win in 2 years as an appellate lawyer. And it was a case where my guy was convicted of 2 crimes. He was convicted of a crime and acquitted of another one. But it was a logically inconsistent verdict. He was convicted of a crime that required both being convicted of driving under the influence and having several driver's license infractions. In New York law, it was called aggravated unlicensed operation of a motor vehicle, a felony. But the jury acquitted him of the underlying crime of driving under the influence. So it was a mixed verdict. The jury says the evidence is insufficient to prove that he committed a DUI, but it's sufficient to prove a crime that requires DUI as a component. It's called a repugnant verdict. It's an inconsistent verdict. And the only reason this happened, it doesn't happen very often, is usually juries, if you're given a series of charges and they want to extend mercy or compromise, they just pick the second one, whatever it is. But the clerk in my case screwed up, and instead of putting them in descending order of severity, so it would be the aggravated unlicensed charge, DUI plus infractions, then the DUI, the clerk flipped them, DUI at the top, aggravated unlicensed. And basically the jury's like, I don't really believe the police here. You know, it was a Brooklyn case, like screw the police. They acquitted on the top and convicted on the second. So I get this case. And it wasn't actually well preserved for review. The trial lawyer hadn't objected to it. And I won on an unpreserved, repugnant verdict. This doesn't happen very often, right, Nan? And I was so ecstatic. I was like high-fiving people in my office. It was great. And then a few weeks later, my boss comes in to my office, closes the door, says, Sue says to me, she said, sit down for a second. This is not the first time this will happen to you, this may be the first time it's happened to you, but it won't be the last. One of your clients has filed a grievance against you with the bar. I will handle it. Don't worry about it. It happens all the time. I'm trying to think, which one? Oh, yeah, Billy's mad at me. I haven't done that. Charlie, yeah. Who? And she named this guy, the guy I had just freed. And his contention was that I hadn't gotten him out fast enough. And so I never heard anything of this grievance. It was a frivolous grievance. So these bar associations will get grievances like that from somebody who is freed on sort of like a Hail Mary legal issue. This sounds like a self-aggrandizing story, but who's freed on an unlikely legal issue and then complains about it. You get cases like that. How do you separate the Barry Levine complaint from all of these frivolous ones? So there are these. Oh, I just gave you his last name, didn't I? There are all these. There are all these potential remedies in the system that just don't work very well. Yes, my Brentwood friend.
Yes, Professor. We have a lot in common. Besides Brentwood, I live on Avon Hill.
Oh!
And I was an assistant attorney general for many years in the attorney general.
Oh, wonderful.
Specializing in federal habeas corpus petitions.
Oh, fantastic.
And I want to defend the system a little bit.
Yeah.
First of all, the federal, as you know, the federal statute, the revision in 1996, made it very difficult.
Yes.
For defendants to file petitions.
Yes.
But to be fair, the federal courts are not really equipped to have evidentiary hearings.
Yes.
And that's why they will remand it, as you know, back to the state courts.
Yes.
Which, that would be the district attorney's office. So, there is an option in the federal courts. They're extremely good. They're very fair.
Yeah.
We do have a 98% success rate, but not 100%.
That's true.
So even at that level, which, as the court now, as the jury now knows, we go through the state system all the way to the top to the SJC and then over to the federal system.
Right.
So there's plenty of opportunities for many of these defendants to speak out. And frequently, motions on the state level, motions for a new trial may be filed at any time.
Yes.
And believe me, they take advantage of that. Yeah. And so you have multiple, because it gets harder and harder as the motion for a new trial process goes. But, I just wanted to sort of defend the system that there's plenty of opportunities for these defendants.
Yes.
Plus, as you know, the 90% of them have pled guilty.
Yes.
So the pleas do relieve offices like my office from these trials. Because the district attorneys are the ones that do all the most of the criminal trials. We do sort of high-flown, white-collar crimes like that. So, a couple of other observations. I don't know any prosecutors that ever wanted to put an innocent person in jail. Yeah. I mean, when you're faced with all this evidence, you have witnesses testifying, this is the guy. You have juries that see the person and judges who assess credibility. Yeah. So at that level, you know, it's a fair process at
Yeah.
that level, you know. But, you know, the example that you brought was very compelling, there's no question. Except that the prosecutor in that case would have been required to be reading the newspaper and see this fellow who may have looked like your defendant, you know, and then somehow get that, you know, and it could have been months after the event. So, I mean, putting it on that prosecutor to investigate that, I think would be difficult. But defense counsel, of course, you know, you always want a third party. You know, put it on a third party, not your guy. But anyway.
No, all valid points.
I want to say your discussion of the appellate process was remarkably objective. And as a prosecutor, I say that. That was very fair. So
Thank you.
I just wanted to make a few points for
All great points. May I respond very briefly, Myra? Do we have time or is time over? Is it okay just for 2 minutes? So just 3 thoughts on that, all valid points. The first is there are lots of opportunities to challenge your conviction. My contention is that they are hollow opportunities, right? They are not fulsome, really substantive opportunities, largely, as you properly point out, because the legislature or other courts have limited your ability procedurally to pursue these remedies. The second does relate to guilty pleas. A lot of people say, and rightfully so, 90+% of people plead guilty. A huge proportion of them must be guilty because why would you plead guilty to something you didn't do? The Stephen Schultz case is an example of why. If you're offered 3 years and you're facing 11 and you are remotely risk averse, might you take the deal even if you're innocent? With my students at the beginning of the term, I often say, if I could promise you a B in this course right now, without taking the exam, how many of you would take it? And then they ask questions. Well, how many people do you fail? How many C's do you fail? But people in the plea bargain process don't have access to that information. They don't know all the evidence against them. They don't have all the data. So there's reason to think, a lot of us call that difference between the offer of a plea and your exposure after trial as a trial tax. It's an 8-year tax on your constitutional right to go to trial, that you might get socked with an 8-year tax if you are convicted. So there have been at least 549 documented innocence cases in guilty plea cases. So, you know, yes, the vast majority of people who plead guilty to crimes are probably innocent, but many are not because of that. And then sort of the last point, right, I think this is you know, a really, really important point, is not that prosecutors would ever want an innocent person to remain in jail. I've taken a lot of care to suggest this isn't an issue of bad apples. It's not an issue of bad people wanting good people to stay in prison. But what it is overworked people with tremendous pressures who create psychological constructs that lead them to think that they got it right to begin with. I read somewhere that the average marriage that's in a poor state, people stay together for 8 years beyond the moment where objectively they should separate. Not a great way to end. I don't know the legitimacy of the study, right? But I think the idea is you're committed, right? And you see everything through the lens of that decision. You minimize the bad evidence, you accentuate the good evidence. Thank you so much. I've gone a little bit over. Thank you. Thank you. What's that?
What's your favorite show on TV?
My favorite show on TV? I liked Boston Legal. Does anyone remember that one? Boston Legal is a good one.